5 seconds to go. Start. NIA owes an explanation for that. The investigation machinery has to be fair, but in this case, paragraph 17.16 indicates to the contrary. Now we come to the provision relating to bail under the UPA, which is subsection 5 of section 43D of the UPA, which reads thus: notwithstanding anything contained in the code, no person accused of an offence punishable under chapters 4 and 6 of this act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Learned ASG relied upon a decision of this court in the case of Gurvinder Singh versus State of Punjab and another. This court extensively considered its earlier decision in the case of National Investigation Agency versus Jahur Ahmad Shah Watali, which deals with interpretation of section 43D5. Paragraph 32 of the said decision reads thus: in this regard, we need to look no further than Watali case NIA versus Jahur Ahmad Shah Watali 2019 5 SCC 1 2019 2 SCC Criminal 383, which has laid down elaborate guidelines on the approach that courts must partake in their application of the bail limitations under the UPA Act. On a perusal of paras 23 to 24 and 26 to 27, the following 8-point propositions emerge, and they are summarized as follows. Meaning of prima facie true. On the face of it, the materials must show the complicity of the accused in commission of the offence. The materials evidence must be good and sufficient to establish a given fact or chain of facts constituting the stated offence unless rebutted or contradicted by other evidence. Degree of satisfaction at pre-charge sheet, post-charge sheet and post-charges are compared. Once charges are framed, it would be safe to assume that a very strong suspicion was founded upon the materials before the court, which prompted the court to form a presumptive opinion as to the existence of the factual ingredients constituting the offence alleged against the accused to justify the framing of charge. In that situation, the accused may have to undertake an arduous task to satisfy the court that despite the framing of charge, the materials presented along with the charge sheet report under section 173 of CRPC do not make out reasonable grounds for believing that the accusation against him is prima facie true. Similar opinion is required to be formed by the court whilst considering the prayer for bail made after filing of the first report made under section 173 of the code, as in the present case. The exercise to be undertaken by the court at this stage of giving reasons for grant or non-grant of bail is markedly different from discussing merits or demerits of the evidence. The elaborate examination or dissection of the evidence is not required to be done at this stage. Stop.